of securities cannot be done in physical form except in case of transmission and transposition. These are the two exemptions they have given. After that, SEBI has issued various circulars directing companies, RTAs, to ensure proper KYC of physical shareholders. And this includes linking of PAN number, Aadhaar, and bank account detail, and issuance of securities only in dematerialization from all investors, with few exceptions that we will discuss. Friends, in this webinar, we will discuss the legal and procedural complexity associated with physical shareholding, especially in the context of disputed ownership and legacy holding, through real-life case categories and scenarios, including missing documents, expired transfer deed, informal gifts, and disputed ownership. The webinar will provide clarity on practical resolution pathway, regulatory expectation, and compliance strategy. Because why this has happened, what is the reason, all these things we will discuss today. This webinar is beneficial for investors, those who are holding physical shares, and sometimes some investors are buying physical share at a discounted without knowing that it will be able to sell it or not, or transfer it or not. Officials of listed companies and Registrar and Transfer Agents. Friends, today we identified what are the issues in the physical shares. So we have categorized in various categories. Number one, and this we will discuss in the webinar. There is one scenario when there is no ownership dispute. So you are holding shares in your name and you are himself holding. So this is the physical share you are holding. You have not converted to dematerialization. That is one scenario we will discuss, that what we should do. Second scenario is that we are shareholder held in the name of deceased shareholder. So somebody like my father has died and his shares I am holding, but it is in physical form, not transferred in my name or other beneficiary. So what we should do. Third category, which we will discuss today, shares held in the name of another person, ownership is not established. What happened? You have purchased shares, you have a transfer deed and share certificate, and you have not transferred these shares in your name. Whatever reason, it has lost, it has misplaced, or there were some issues going on. So how you can do this? Then sometime what is happening, where only transfer deed available, but share certificate is missing. So you purchase some share, you have not sent for the transfer, and in the meantime, share certificate is also lost or mutated or some other situation has taken place. In another scenario is where you have a share certificate in the name of some third party, you don't have a transfer deed. And when you are contacting that person, he is not transferring. Where payment proof is available, sometimes what is happening, you don't have share certificate, you don't have a transfer deed, but you have a payment proof available with you. Next scenario is that the payment proof is not there, but you have a broker slip, the contact note of broker, that is there. No transfer deed, no share certificate is available. So these are some criteria where ownership is not established. Then fourth criteria where ownership is in question. Like you have all these things, but simultaneously there is a dispute also, there is a court case. Then another scenario is you are holding shares, but your shares has transferred to IEPF because your address was not updated and the dividend was coming, it is got refunded by the last address. Then KYC requirement of physical shareholders. So friends, we all discussed these issues today, and some new scenario which we have not covered, Kunal and Savitri and Raghav will tell us, and Pisha will do this. And for this program, we have invited none other than Mr. Jeevan Sonepatre. He is the Executive Director at SEBI. He is also very extensive, versatile experience over 30 years working in several departments of SEBI, including secondary market department, investigation, investors, awareness, education, enforcement of SEBI, action against fraud and insider trading cases. He has also been Chief Public Information Officer and Adjudicating Officer. I welcome Jeevan sir for this program, and I'm so grateful at a very short interval you have accepted our request and joined this. And because Jeevan sir is in charge of this particular department, and SEBI has formed a committee also where Jeevan sir and Savitri is also member. She's just joining. So we'll get the insight, input, and the help to the investor as well as companies, those who are facing this type of problem. So I welcome Jeevan sir for this program. Then I extend a very hearty welcome to our other learned speaker. First, Savitri, she is just joining. She has over 30 years of corporate experience in company secretary and compliance officer, Reliance Industry. Worked in variety of sector, including manufacturing, outsourced, private equity, media, pharmaceutical, textile, chemical. She is a specialist editor of Ramaiya, Guide of Companies Act. And I always tell this, she's Chalta Firta Ramaiya. She knows section, subsection, proviso on her fingertip. So I welcome Savitri, the Chalta Firta Ramaiya, and we salute you. Then we have a Tonal Ghoshal. He's a Deputy Secretary and Head Investor Service Center, ITC Limited. He possesses more than 28 years of experience and has been associated with ITC Limited since 97. And I will just tell about the Tonal that in all of us, he is the person who has faced maximum cases of this type of thing. And he is the right person. When I contacted Rajendra Singh, Company Secretary of ITC, he told me that, Pawan, I am not aware of much thing. Tonal is the best person who knows these things. So Tonal, welcome, and your experience and guidance will definitely help. Then we have Mr. Raghav Chaudhary, the Vice President, the Wealth Finder, and Raghav is handling these type of cases, helping investor for getting the IEPF shares and the demat shares, physical share into demat, how to do it. So Raghav is a experience in this. Then we have Ms. Piyusha Sharma. She is Manager Operation, Wealth Finder. She is looking after operation, and she is ultimately receiving investors' problem and solving them. So this is our thing. And one is regulator is there. Second is the company, which has the maximum number of physical shares. And then we have the user, those who are helping investors. In my estimation, and as per the data available, more than 3 lakh crore rupees physical shares are in the market, which has not converted into demat. And other information we will also get. Friend, before starting this session, I'll just inform you that our knowledge journey is going on. On 6 June 2025 is the occasion of World Environmental Day celebration on 5th June. We are organizing a program of decoding EPR for FIBOs from compliance to implementation. So this is a program which is connected to ESG, and we will discuss hardware things. Before handing over to Jeevan sir for his inaugural address, I'll just tell you, I'm a professionally company secretary and lawyer, but my life has started with bad delivery. I got a first job in a broking company, and when I met the promoter, he asked me, "Are you aware of anything about the bad delivery?" So I was not aware. So he told that we are having a shares which are not transferred because signature not matching, some other issue, and I joined that company. And that particular time, I did research, and without boasting, I made a bad delivery comparison. That time, another interesting issue was there. The Delhi Stock Exchange, Bombay Stock Exchange, Calcutta Stock Exchange, and other 23 stock exchanges all were following different norms of bad delivery. So I made a comparative chart and I presented Mr. Nathkandi, who was a chairman of SEBI. He's no more. I gave it to him and he told this is a very good analysis. And then I met SEBI officials uh, and then they came out with a document how to make it this particular thing. And it was a business line headline. My chart was published there. So bed delivery is a life starting point of my career. So, and we were, and I have seen the days also when our company was doing transaction and we have a separate division of bed delivery, around 10 to 15 people they were doing. And I remember that day also when broker were having money, broker were having a capacity, but they were not purchasing more share because they can't handle physical shares. And in the physical share, the fear is that bad delivery, they cannot manage in such a manner, which is not there. So all the new people, they may not be aware that what is the meaning of bad delivery and how it is connected, but that is a part of the system. And every broker who has succeeded in their business or failed because of the bad delivery and because of the loss of that. Those who have a good management, they survive, and those not, they didn't. And the companies also, they were also having. So today we will discuss all issues, and during the question answer session, I'll share my thought and my experience with all of you. So Jeevan sir, your inaugural address for all of us, please.
Thank you, sir. Thank you. Good afternoon to you, and thank you, corporate professionals, for giving me an opportunity to articulate some of the thought processes SEBI has with respect to this particular topic. I am sure you have a illustrious panel ahead, so their inputs will be much better as far as dealing with practical situations. But from a regulatory perspective, we are just trying to provide what kind of activity or efforts we are trying to do to ensure that we have less number of physicals and more on the demat form. So as a regulator, what we try to do is that we wish to even change the investor psyche. There are investors which we have interacted with where some of them, despite being educated, despite being tech savvy, would still want to hold on to the physical certificates. There are investors which we have, some of the companies that we have been told, where investors don't want to part with the physical shares because they want to see something in physical format in their locker or in their folder. And there are others that have ornamental value for the signature, or somebody has signed, some illustrious promoter has signed on the certificate, so he doesn't want to part with that particular thing. So these are some of the ways why we feel that the physical certificates still continue. A large part of the physical shares also continue because either the person has made the investment, forgotten, and it's now been discovered by his son or daughter after he has passed away. So those are the kinds of cases that are now coming up. So clearly, this is a major issue as far as the regulator is concerned, and both regulators, the registrar transfer agents, and the companies are trying to deal with one or some kind of problems related to physical shares. What we are trying to do is in two phases. Is first to stop any more physical issuances. So if you have noticed over a period of 2-3 years, any kind of issuances or any kind of, at least for the primary issuances, in which case it is compulsory to be made in demat. We also mentioned that rights issue should again be in demat. Progressively, we have last 2 years ago, we have mentioned 2 to 3 years ago, we have mentioned that even bonus issuances shall now be in demat form. Going forward, you will find that any corporate action, including split consolidation, the consultation paper was released 2 months ago on this particular issue. That also, we will clearly say that any kind of structuring, restructuring, split, amalgamation, everything will now result only in demat, and no physical shares shall be provided to the investor. So this is how the regulator is trying to move ahead. Clearly, this will stop the flow of any new or fresh entities coming, fresh physicals coming into the market. The other issue that remains to be handled is what happens to those cases which are already there or those that are already in physical, how do we deal with that? So clearly, this is a problem SEBI realized more than a year ago, and we deliberated as to how to go ahead with this. Fortunately, the broker, there is an industry standard forum for the registrar and transfer agents, where they came up with the idea that we should have some kind of a panel where, based on a case-to-case basis, if we are able to ascertain the genuineness of the case, even physical transfers, which are prohibited today, can somehow be considered and put through, because there's no point holding on to the physical shares even for the shareholder as well as for the entire ecosystem. So somewhere in the month of May, in this month itself, we are started working on some exercise that will allow investors who are holding their transfer deeds in physical will find a way out to allow them to lodge their shares with the registrar for transfer. So this will be a one-time window we will be considering. The report of the committee is yet to be out, but this is how we are thinking. This is what we are trying to do. The major focus of the entire exercise, whether it is stopping new issuances in physical or the existing physical to be dealt into demat, is to ensure that the investor is protected. He holds his shares in the demat account so that it is easier for him to transact in this particular securities market and reap the benefits of his investments that he has made in the securities market. So this is the effort, and I think this workshop or your session has come right in time and coincides with one investor Shibir, Niveshak Shibir, that is being conducted on a pilot basis in Pune, that is being held on 1st of June. Along with SEBI, IEPFA and exchanges, we are conducting that Shibir. Shibir is a camp where shares that are going to go into the IEPFA from 4 years to 7 years, we will be dealing with those investors, or those that have already gone there, how to get them out. That entire process will be explained by the company nodal officers, as well as by the RTAs that are going to be present in this particular Shibir. So that is on 1st of I'll just tell you that, just confirm the date. 1st of June is the date, and I think the time is at around 11 o'clock. And I'll share with Mr. Vijay the public notice, so that it can be disseminated to all the public. It's at 10 o'clock, 1st June, 10 o'clock to 4 o'clock. The venue is Lemon Tree Premier City Center, Pune. And this is very close to the Pune station. For logistical reason, it's not more than 200 meters from the Pune station. That's the junction that is there. So people should reach out to their colleagues or relatives or friends that have shares that are being stuck in the IEPFA. There will be people here in this seminar in this particular Niveshak Shibir, to guide people to ensure that their shares can be retrieved from the IEPFA. So this is more or less the efforts that SEBI and IEPF and others are making, either for ensuring that we have a more demat and physical is removed, and also for ensuring that the IEPFA shares can be retrieved from the IEPFA. Thank you so much, and all the best to the seminar, Pawan Kumarji, and the other panel members on this particular seminar. Thank you so much.
Thank you very much, Jeevan sir, for informing this Niveshak Shivir also, and then the SEBI's thought process. And I know actually my inspiration came out for this program by Savitri. I met her in Bombay, and she informed me that this SEBI has formed this committee of physical shares, and that was there. So Savitri, what I'm suggesting, Piyusha will give a presentation on, she's covering all the points. So then you will start what are the solutions, what are the issues of different things, and Tonal will add. You give your experience and solution, and after that, Raghav will discuss this. Okay. And I know Jeevan sir has a urgent meeting, and he has joined for this program. So I thank you, Jeevan sir, for this program. And over to you, Piyusha.
Well, thank you so much, sir. Well, good evening, all the panelists and all the viewers here. As Jeevan sir and Pavan sir has rightly quoted, like the issue the physical shareholders are facing right now. So I've prepared a small presentation to share here, uh, so that we can, cover majorly all the points. I hope the presentation is visible to all. The screen is visible to all. Can you please confirm once?
Yes, yes, carry on.
Yeah. So I'm presenting from the organization, the Wealth Finder. We are the Lost Wealth Recovery Consultants. We are dealing with the physical shareholders on daily basis, and listening to their issues and queries on daily basis and dealing with them. So, well, first of all, I would like to ponder upon this very first the topic of the webinar is the end of physical shares. So, this is really a question of all the physical shareholders across India. Whosoever, specifically the physical shareholders who are holding shares, they wants to know that the piece of paper is like the share certificates which they are holding in their hand is just a piece of paper, or what to do about it, because given the circumstances they are in right now, given the amendments, the circulars which which the government has issued so far, that is turning out to be just a piece of paper, because those share certificates are not tradable anymore. So given this, we will be discussing in this presentation, like why this physical shareholders is actually a concern for the shareholders. What can be the different scenarios and cases in which you hold those share certificates? What can be the possible resolution for that? Then we have tried to cover each and every scenario in and the form in which you can hold you might be holding the physical shares. What are the procedural challenges which you as a physical shareholder faces, and what can be an advice to you to you as a physical shareholder. Well, why is this physical shares a concern? First of all, see, government is trying to make efforts right from the start to digitalize the entire process. The journey started back in 1996, when there was that it was a start of transition from the physical shareholders from the physical shares. Then in the era of 1999 to 2000, the demat was made compulsory for all the IPOs and the stock exchange trades. Then in 2018, it was the base of the entire hustle that was created for the physical shareholders, where SEBI has given a advance notice that there will be a ban on the physical transfer that will be announced. And by the end of 2018, it was formally announced that 31st March 2019 will be the last day to launch the physical transfer requests. 1st April 2019 onwards, this was effective. The physical shareholders were left hopeless, like, because they could not transfer any shares in the physical form. So in 2020, the government again, SEBI, allowed ki, what happened, how the physical shares were transferred. They used to lodge one share transfer deed to the company in the form SH4, and that physical transfer was completely banned. However, SEBI allowed that till 31st March 2021 being the last cutoff date, wherein the physical transfers can still be allowed, but it is allowed only in the cases where the initial cases were already lodged until 1st April 2019. So only the transfer deeds that were defective or transfer deeds that were rejected by the companies can be relodged, but by maximum by 31st March 2021. After that, there were no fresh or relodgement of any physical transfer deeds were allowed. Then from 2021 to 2023, there were various circulars that were issued by SEBI pushing the physical shareholders to get their shares demat as soon as possible. And they have prescribed various regulations also to simplify the process, to get the KYC completion done and ultimately get the shares demat. See, this is a concern because if we go by some industry estimates and the research reports, the overall market size of physical shares across listed companies is approximately 4 lakh crores, which accounts for 1 to 1.5% of the total shareholding in the securities market. So this is really a very big market size, which government is trying to address every now and then. And the second major concern is the attitude of the investors. The investors has the complete neglect kind of approach. Investors, even if they're aware that they are holding shares, they are holding physical shares, they are, they have a neglect approach. They do not want to get into that process to get those shares demat. Then even if the investor, sometimes what happens, investor is not even aware. Then in such circumstances, those physical shares remains physical forever. And even if the investors, if they are aware, they're not interested to get it done because of the legal complexities or any of the hustle. They think it's time consuming, it's cost will be there, efforts will be there, so they completely neglect that. Then there some of the shareholders that comes to, that we approach, they also have that conservative approach, that the shareholders which they're holding in hand, if they'll get it digitalized, they will lose them forever. So they have somehow mistrust over the digital system or something. Then mostly what happened, various families, there is an attitude, like these are, there is actually a litigation prone families. There is a lot of disputes going around among the legal heirs, like who is going to claim those shares, which is why those physical shares remain physical till date. So this is actually a loop of physical shares, just few scenarios, what happened, as Jeevan sir has already told, Pavan sir has already told, various circumstances are there due to which these shares remain stuck in the physical form. Might be the address of the shareholder has changed. Okay, might be the person has lost the share certificates, is not even aware of the physical share certificates. He is, even if he is aware, but he does not know the correct procedure to claim those shares. So multiple reasons are there due to which the the loop of physical share continues on and on. Well, what I personally, what I feel is ki the second major concern of in this physical share is like the form of holding of the physical shares. You know what happened? There are various shareholders that come to us. They have a multiple shareholdings in delisted companies. Okay, in unlisted companies, closely held companies, and sometimes they have the holdings in the multiple companies. The market value is so low that the cost of recovering those shares comes out to be more than the market value. So which is why there are multiple what I feel is, even when the major chunk of this physical shareholding market is even if it is digitalized, still this sector will remain untouched to an extent, because this has no solution to it further. Like what you as a shareholder, or I as a shareholder, what will do with the shares of this value. Then, moving further with the different scenarios and the resolution process, uh, there are different scenarios in which you, as a shareholder, might be holding shares. One by one, we'll be taking all these scenarios, we will be discussing. See, might be you are holding shares in the name of yourself, and there is no ownership dispute. It's a clear cut case. The shares are held in your name, no issue. Simple enough, there is a simple process, as SEBI has already prescribed the guidelines back in 2021, then in 2023. You have to run through the process of the KYC updation with the company before getting those shares demat in your account. Now, KYC updation, simple enough. You have to get your name, you have to get your address, bank details, demat account details, all verified with the company. Once that verification process is done, your KYC process is done, you have to lodge certain set of documents along with that. There are forms like, KYC updation forms are there. There are some nomination forms. We'll come across with the entire list and the entire process in the coming slides also, wherein we'll be providing the comprehensive list of documents that is required at your end to get your shares demat. So it's a clear-cut case. You have to just lodge all the documents. You have to do the KYC updation, lodge all the documents with the company. Company will issue you the letter of confirmation, and you can get that letter of confirmation submitted to your depository participant within 120 days of that letter of confirmation, and you can get your shares demat in your demat account. Now, second scenario can be you are holding shares as a shareholder, but the ownership is not in question, but the shareholder is not alive. Might be the shares are held in the name of your, the name of your grandfather or your father or anyone, but the shareholder is not alive. But one thing is clear, ownership is not in question. You're quite clear enough at your part who is going to claim those shares. In such scenarios, it's also very easy to note what whosoever will be the claimant, you have to get the KYC updation, the KYC verification of that claimant with the company. You have to lodge your all KYC documents along with that KYC forms, which we will be discussing in the coming slides. You have to just lodge them all with the company. But one proof, obviously, you will have to provide, wherein you will prove yourself as the claimant of the deceased shareholder. That one document will be either a legal heir certificate or a succession certificate or a will or a probate of will. These document, this is very important document. However, as prescribed by the SEBI, there was earlier an indication that if you're holding market value of shares less than 5 lakh, then the legal heir certificate would have been was a sufficient proof. If it is more than 5 lakh, the succession certificate was always needed. But as per the recent amendment that took place, the legal heir certificate is still valid if you're holding shares of market value more than 5 lakh. Still, you can, with the help of legal heir certificate, you can lodge to the company and get your shares demat. Similar process, give all the documents to the company. Company will issue the letter of confirmation, or if your shares are transferred to IEPF, the letter of entitlement, lodge it with the DP and get your shares demat. Then moving further, the problem actually arises when the ownership is in dispute. The shares are held in the name of the deceased shareholder. Shareholder is not alive, but the ownership is in dispute. There are various cases, where the shareholders come to us, and there are various scenarios in which it becomes very difficult to identify, like whether the how to claim those shares, how to get those shares demat. If you are holding shares, if there is any dispute, the first major very prevalent issue that comes up is between the nominee and the legal heir. Sometimes the deceased shareholder has already nominated some person as a nominee, and technically the shares are transferred to the shares, the nominee go to the company, claim those shares, but legal heirs comes into picture, claiming that to be their property. So as per the decided case laws of Supreme Court, nominee is mere trustee of the shares for the legal heirs, but the ultimate owners remain the legal heirs themselves. Legal heirs always have a better entitlement of the shares as against the nominee. So this needs to be very much clear. So if you are holding shares as the nominee or you're holding shares as a legal heir, if you're holding shares as a legal heir, it's also very important to understand like who are the legal heirs. So as per the Succession Act, there are classes of legal heirs of the deceased person. So in the class 1 legal heir, there is a person whenever dies, the spouse, the children, and the children of the predeceased son or daughter always accounts for the class 1 legal heir. So you have to first of all identify at your end that whether you are a legal heir, might be the legal heir is also a nominee or might not be. But you have, if you are a legal heir, so you can sit back and relax. You can go to the company and claim those shares. Sometimes what happen, there is a dispute wherein between a de facto partner and a legally wedded wife. Now, as per the decided case laws, legally wedded wife always has a better entitlement of her shares as compared to the de facto partner. Now, there were case laws also being given. De facto partner jo hai, but the live-in partner, which we say, she does not has any automatic succession rights. Also, but the children of the de facto partner always treated as the legitimate children of the deceased person. So the children of legally wedded wife and the de facto partner will always be the legal the claimants of the shares. Now, there can also be a scenario whether the person who has deceased, he has done two marriages, the children from the first marriage or a second marriage. Again, you have to first identify that whether that first marriage was being the first marriage has been divorced and the second marriage existed. So if the second marriage is there, children of the second marriage as well as of the first marriage, as I quoted earlier, both will be the legitimate legal heirs. There are also cases when there are verbal wills and written succession rights. See, written succession rights always has a better title as compared to the verbal wills. And whatever is written, it has a better title, obviously. Then moving on further, the ownership in dispute, the process obviously remains same. Who once the ownership of the person is identified, like who is going to claim the share, once the claimant is clearly identified, who is going to be the claimant, then you can run to the company, you can get the KYC verification done as a claimant, obtain the share certificate details from the company, and move to the court obtaining the succession certificate or a legal heir certificate, furnish all the documents to the company, obtain the letter of confirmation or letter of entitlement, and get your shares demat. Now, one note to the claimant or investor is, sometimes it happens, the disputes between the family members is such that which acts as a barrier to let them claim their shares. So I would simply advise let wealth not be the victim. It's always better that you can always sit together, mediate, and mediation is always a faster, cheaper, and more human approach. Because litigation will, it means more time, more money, and more uncertainty. You must think bigger than the disputes. And because family disputes can actually turn your assets into dead capital, that is why it is always advisable कि instead of moving to the court, let the battle solve before you enter into the court gates. Let the matter be resolved earlier, and so that you can get those physical shares demat as soon as possible. Now, there can also be a scenario, these were very simple cases which we have discussed so far. The actual problem arises when there is a problem of unestablished ownership. There are cases wherein, the shares are held by persons in the name of person who's someone else. So you sometimes you do not even know that person. In the past history, if you have purchased shares from someone, like as sir has quoted just earlier, bad deliveries wale cases, might be you have purchased shares from someone and you have already made the payment to that person. The physical share certificates are in your hands, but still in the records of the company, the transferor's name is still appearing. So in such scenarios, these scenarios are multiple in cases, and you as a shareholder get stuck at this point. So what can be the possible action, and what can be the possible way to get this thing resolved? We'll discuss this. See, first is, as might be the case, you are already holding the transfer deed with you. Now, as we have already discussed, that transfer deeds are completely banned with effect from 1st April 2019. Now, there can be a scenarios where transfer deeds were relodged after 1st April 2019, but until 31st March 2020. Now, still, you might be holding some transfer deed in your hand. You might be holding share certificate in your hands, and you want to get those shares in your name. So there can be a scenario like what all different conditions that needs to be checked to get those shares demat. You have to first check that whether deed was properly executed or not. To check the proper execution of the deed, first we need to see whether the transfer details are completely mentioned. Might be, there was no proper stamping at all. Transfer deed was executed, but it was not executed properly. So if this is the case, there are in these circumstances will either strengthen your claim or it will weaken your claim. So if you're having a transfer deed and if you're having a share certificate, you always have a strong claim at your hand. You can No, see, though it is a strong claim, but it's still a prima facie evidence, but it is not a conclusive proof. You can move to the court straight away, giving them, the justification, like you have the transfer deed, you have a share certificate. If you have the payment proof also, in that case, your claim will become very much strong, and you can get you can get the order in your favor. However, if you do not have any share certificate available, you only have the transfer deed available in your hand, you do not have any share certificate, then it will lead to a very moderate claim. You will have to first approach the company to see whether might be the share certificates are available with the company. And if that is not the scenario, obviously the legal route will be the only last resort for you. There might also be a case that you're holding the share certificates, but you're not holding any transfer deed in your hand. It will still be a very weak claim, though it is a strong evidence, but still a weak claim. See, again, the legal route, the legal remedy is the only last resort available at your end. If you have the payment proof, you do not have any transfer deed, you do not have any share certificate, you must try to trace the broker history and records to collect sufficient proof at your end to prove your case is genuine, and accordingly the decision can be passed in your favor. So this is how the different the unestablished ownership can be dealt with. The last resort is always the court only, wherein you can get the case resolved there. Well, I would like to ask companies also, in sir, if you could allow at the company's stand also, because I want to, as an investor, would like to ask few questions, because these kind of scenarios keep coming up as an investor, and sometimes what happen is few companies uh, accepts the cases and few companies straight away rejects the cases.
Let
So there is no
Savitri and Tonal will explain this, that what is the correct picture, correct things. So we will just work out.
sure. So points to note here is, see, as per section 59 of the Companies Act, the rectification by tribunal, the rectification in the register of members can only happen, when there has to be an existence of original share certificates and transfer deeds. Why? Because it creates a prima facie evidence, but however, it is not a conclusive proof. There still has to be various other things like payment proofs and other proofs that are required for the court to court to give the final order in your favor. Now, just a mere possession of documents is not important, is not sufficient, and just a possession of documents is important, but it is not automatically decisive. Court also looks into the facts completely. Now, sufficient proof for genuine ownership is always mandatory, and also there should not be any case of fraud or forgery. Lastly, what is seen is the intention of transfer and consideration is seen only in such circumstances the court passes the order in your favor. Now, lastly, the next scenario is when the ownership is in question altogether. Now, there are cases wherein person comes to us wherein they are holding share certificates in their hands, but another person has already claimed the ownership, due to which the company has marked stop transfer on few cases. So in such scenarios, obviously the legal remedy is the only resort available with you as a shareholder. You can, with sufficient proofs, move to the court and get your claim justified there, and only in such circumstances the company resolve digitalize those shares in your favor. And in some cases there are some informal gifts also. Sometimes it happens ki person comes up saying ki my father has gifted me shares, or my grandfather or grandmother has gifted me shares. So if there is no documented thing for that gift, so that claim becomes very weak, and in most circumstances, you cannot be treated as the rightful claimant of those shares. Now, the second scenario is when shares are transferred to Investor Education Protection Fund. No, this is also, a different category because shareholders keep coming up. However, there is no major difference in the process involved. Only one extra added layer of compliance is added, wherein you have to file the claim before the Investor Education Protection Fund Authority and get your shares demat from there. The process altogether remains similar. You have to do the KYC verification. If you, as a shareholder holding shares, you have to do a KYC verification for yourself. If a claimant is holding shares, a shareholder is holding shares, the shareholder has deceased, then the claimant has to, get the KYC verification done with the company. And then you have to lodge all the documents, the comprehensive list we have provided. That list of documents you have to lodge with the company. Company will verify the genuineness of the claimant as well as of the shareholder, will issue the letter of entitlement or the letter of confirmation to be further lodged to DP or IPF to get your shares demat. This is all in all a very simple process. So you have to just, once you get the letter of entitlement from the company, you have to visit the IPF website. You can fill the form there. And after filling the form, all the details, you have to lodge physical submission of those documents with the company for further dematerialization. This is a comprehensive list of documents. In general, simple KYC related documents are required: your PAN, your Aadhaar, your bank details, your demat account details, signature verification form. You have to lodge all these forms. In case your shares are lost, then you have to submit FIR, the affidavit indemnity. And if the market value of shares exceeds 5 lakh, both cases, both FIR and newspaper advertisement is required in such case. Then, if it is a transmission case, as we have just know where the shareholder has deceased, you must ensure that the death certificate of the shareholder is available. You have to ensure that it is properly notarized and properly self-attested by the claimant. And you have to lodge it along with the court order, succession document, will, probate of will, or legal heir certificate for along with the affidavit and indemnity to get your shares demat. Now, if you fall into any of the category with the scenarios which we have just discussed just now, wherein you have obtained the court order, obviously that court order will be required in place of these succession documents of this will and probate of will. Now, during you as an investor, obviously various challenges are there in the process of dematerialization. When we go by the KYC update, sometimes various cases like happens in the name related issues that comes up. The person's name is suppose Ajay Kumar, but in the share certificates your name is only Ajay. So in such circumstances, it's a name mismatch issue. So you have to resort to the Gazette notification before getting your shares demat. So Gazette notification is if there is a minor mismatch in your name, like spelling error or misspelling, then simple affidavit is sufficient enough to for this name related issue. For address related, you always, you must ensure that you have your address in the old address proof you have with you. Even if you do not have that, a simple affidavit will solve the purpose. It's also very important to ensure that whenever you are moving with the company to get your shares demat, the bank details, the name and the address you have in your demat account should match with the details in the bank account. Sometimes the mismatch in both the accounts causes problem in the processing of the physical shares. Then you must also ensure to get your signatures verified with the bank. And it sometimes it happens, your signatures are not matching with the records of the company. In such scenarios, the verification and attestation from the bank is needed to further record it in the company's records. Then there are various procedural related issues obviously happen. You must ensure few things at your end before getting your shares demat. You must ensure that all the documents which you are submitting with the company are self-attested and they are properly notarized. Sometimes it happens, the person, you as an NRI, is holding shares and you have to proceed with the companies here in India. Then you must ensure that your documents, whatever documents you're signing, obviously, I mean, all the legal documents which are signed, like affidavits or indemnities, they're totally apostilled at the place where you're residing. Or you can also appoint, the power of attorney here in India to get those documents notarized and file it with the companies. Now, this is all in all the KYC requirements which we have discussed just now. For your name, your PAN number, your permanent account number, or Aadhaar or a bank statement is a sufficient proof to be given. Then you have to give your bank account details, your address proof. These basic KYC documents you must have, and the documents must be complete in all aspects to be given to the company. Various challenges and issues which are faced by the investors in filing the IEPF claims. Now, the major issue happens with the letter of entitlement. From the point of view of the investor, it becomes very difficult, to obtain the letter of entitlement from the companies, because there are unnecessarily delays in providing the letters. Multiple follow-ups are required to get that letter of entitlement or the letter of confirmation for further process. There is also, non-availability of the real-time information of the claim, which leads to information asymmetry for the claimant. The shareholder, even after filing the claim, faces issue like there is no real-time mechanism where he or she can track where his or her file has reached. Then at times we have seen we have to take multiple follow-ups from the companies to file the verification report after filing the claim. There are also cases wherein, documents have already been submitted to the companies, still that documents are required to be filed at the time of IEPF claims. So I think it's a duplication and a dual process which is involved in filing the claim process, which should not be there. So there's also a problem which we face as the shareholder face, like sometimes, the claim is altogether rejected without giving any opportunity to the shareholder or claimant to rectify the errors. So if there is a mechanism where, a simple mail can be even dropped from the authority or from the company and given a chance to rectify those errors or issues, it would actually solve the problem of the investors, and it will save time. Well, there are some common misconceptions of the investors. The investors think that the share certificates lost means means they are lost forever and they cannot claim the shares. No, this is not the scenario. It's very important to note that sometimes what happens, even if you're not holding physical shares, might be those share certificates are held with the company. So it's always better to approach the company and find out whether might be the companies are holding those share certificates. And even if the company is not holding those share certificates, you can still run through with the entire process to get that share certificates issued in duplicate to you. Then shares transferred to IEPF is not lost forever. You can run through with the entire process of that KYC verification and lodging of all the documents, and you can simply get your shares transferred in your account. Shares will be transferred to their demat account with just, because sometimes, shareholders think just because they have filed the form, and the very next moment the shares will be credited to their account. So it takes some time. It takes time. Once the shares are, once you file the claim, the authority, the company files the verification report with the authority, then the authority verifies it, then gives an approval or rejection. And even after approval and rejection, it takes some time to get these shares demat. Just because you are holding the share certificate does not mean you are a shareholder. We have already discussed the cases. You have to first identify, especially in the cases where the shareholder has deceased, you have to first identify like who is going to be the actual claimant. And if there is a dispute in that, You must first mediate, you must first identify, and then move to the company, because it will save your time and efforts. Then shares in IPF are not dead, and dividend on those shares are still there. Once the shares are credited in your account, the corresponding dividends will also be credited to your account. So it's not lost. Nominee, as we have already discussed, between the nominee and the legal heirs, nominee is never the ultimate owner. Nominee is just mere trustee of the shares, but not the ultimate owner. Then a simple advisory note to all the investors. You must get your shares dematerialized. Government is making efforts time and again to push these physical shareholders to get your shares demat, because this is really a major concern. If the physical shares hold, if this digitalization does not happen in time, you might, you never know, you might lose the chance to get it demat then. So it's always good to get your KYC updated with the companies, with the mutual funds, get your shares demat, claim your dividends promptly. You must also, appoint a nominee for your investments. Once they are dematerialized, ensure that you appoint a proper nominee. We advise you keep an organized record of your investments, you monitor your investments regularly, and you must be aware of all the unclaimed shares. You must educate yourself on that. You must also have a proper family succession plan, and wherever a professional help is needed, you must take that help for getting your shares demat. So with this, I end this presentation. Thank you so much.
Thank
Sir.
you, Pisha, covering the broader aspects and complete aspects in the problem. Now come to the solution and the issues, which because sometimes what is happening, you are seeing one side, which is looking that why companies are not doing, why regulator is not taking action, but you have to understand the other part also. So let's listen from the horse's mouth. So Savitri, you are having the highest number of physical shares in the country, and then come to the Tonal. So both two person we have invited, and I think both person can cover up the entire industry's problem. Whatever problem, if any company has, you must have this type of problem. So over to you, Savitri. Open to discuss now. Piyusha has explained everything. Now, in this topic, because you have created this topic for the program, so please uh, take forward. And then Kunal, you'll be ready after that. Yeah.
Thank you very much, Pavan. It's indeed a very good topic that you've taken up, because this is something which concerns companies equally as much as it concerns the shareholders. In
Yeah.
fact, both Tunal and I would actually like to say that if shareholders dematerialize their shares, we would have a more peaceful existence, for the simple reason that with respect to a physical share, of course, SEBI has stopped transfer of shares, but let's take a step back and look at the kind of evidence which companies had with respect to physical shares. Dematerialization was introduced because there were a lot of problems with respect to physical shares. With demat shares, fortunately, a lot of these issues have got addressed very well. India has a very good system with the two depositories which form the backbone. Of course, we have close to 1,000 depository participants, but the control is exercised by the depositories, CDSL and NSDL, and that has certainly proved the test of time. 1992, this particular regulation was passed, and I don't think most of you all would know, when the depositories regulation was passed and DMAT was introduced. I was working for a pharma company in Calcutta, and an article of mine was published in Telegraph with respect to dematerialization of shares, and where I had said that it was a very good move, and it's only a question of ensuring that the systems support it, which we've actually seen it working very well. Let me take few of the issues. With respect to physical shares, what is it that the company had which proved that it was shares of so and so, proved quote and unquote? Because when transfers were being done, what is it that the registrars checked? only the signature, name, and address. So if these three were right, the transfer was approved. Now, if you look at the transfer form which was being used, except for the signature and name of the transferor, there was no common denominator which required checking. Result of this, there were several litigations with respect to shares where companies were being dragged into it, where actually the company had a very, very low role to play. For that matter, succession disputes with respect to shares held in physical form, companies made a pro forma defendant. And some of the courts insist on the company representative being there or the lawyer being present in those cases where actually it's a property of Mr. X. Mr. X may probably not have, his legal heirs may not have any dispute among them, but the company is unnecessarily required to spend money on this succession related matter, where the company is just a pro forma defendant, where they go and tell the court that whatever you decide, we are willing to go by it, whether it is X1 or X2, company has nothing to do with it. Let's take the third case of attachment. Attachment by the regulatory authorities or attachment order passed by the court in some private dispute. Companies used to get these orders and companies were required to mark all that in the register of members. Now, in case these shares in the meantime had already got transferred, companies would actually have to inform all this. Now, in the demat mode, it's very safe. Company is nowhere in the picture. Whatever is required, the depositories ensure that there is a marking done either on the particular DPID client ID of the customer concerned, that is of the shareholder concerned, or maybe with respect to a particular ISIN, as the case may be. So, in short, if the shares are in demat form, companies are not going to be involved in any dispute. I don't have a single dispute with respect to a demat holder having a succession dispute with his or her relatives. Now, with respect to the different scenarios, it was very beautifully covered by Piyusha. And of course, I'm also looking forward to hearing more from Tunal with respect to the practical issues. But let me also take a step back. In fact, Pavan, when we initially discussed about this topic, I said that with respect to shares, there isn't a single common factor which links the person to the shares. For example, it is mandatory to link PAN and Aadhaar even to physical shares, which was initially introduced by the circular of SEBI of 3rd of November 2021, where extension of time was being granted by several circulars of SEBI, 16th March 2023 circular, 26th September 2023 circular, where extensions were granted. The last circular is of 26th of March. And in fact, today, if the shareholder is holding shares in physical form and has complied with 6 KYC, there is absolutely no bar in holding shares in physical form. However, transferability later will be an issue, and God forbid, in the event the shareholder passes away, at the time of transmission, once again, papers would be asked. For example, if nomination has been done, thanks to Companies Act 2013, from the company's perspective, the nominee will be considered as the person entitled to the shares. If at all there is a case that is going on in the court, it will be separate. However, if the shares are dematerialized, it's a great protection for the company, and it also becomes very easy for the company to handle, no matter how many shareholders you would have. Let's take the case of 6 KYC. If the shareholder who's holding shares in physical form has been regularly encashing his dividend and has complied with 6 KYC, as I mentioned, there is no issue. Where the shareholder who's holding shares in physical form has given his email and has been regularly encashing his dividends and has also given a bank account details, but has not complied with 6 KYC in full, in totality, his dividend for 2024 would not have been released by the company, because the circular said physical shareholders holding shares, I mean, shareholders holding shares in physical form should have complied with all the ingredients of 6 KYC. So, which basically would also include giving mobile number, give address proof. PAN, of course, would have been given. Even the income range is supposed to have been given. In fact, it's very interesting to note email address, the circular refers to valid and active email address. Now, valid and active, unlike in case of bank account, there is no penny drop that is done. When you issue the notice of the general meeting, you have bounce back. But valid and active is for the shareholders to ensure and ensure that it is complete in all respects. Having said that, effective December 12, 2024, SEBI LODR has been amended with respect to Regulation 36(1)(b). If a shareholder is holding shares in physical form, because that is the topic that we are discussing, and has not updated his email address, going by the 3rd November 2021 circular, service request will not be entertained. However, I would hold that with respect to sending of this letter, one needs to take a call and examine as to whether this letter is he entitled to or not. I would say it's better to comply. If he is not given his email address, send him this one pager which has the path, but you're not required to send the physical report, which has been very clearly stated even in the amended LODR provision. Typically, with respect to dematerialization, I would just like to spend 5 minutes on dematerialization and hand over to Tunal. Typically, when we receive requests for dematerialization, what is seen is shares are held in individual name while the demat account is in joint names. Now, let's assume we were to look at it as original old practice of physical shares. If the shares were held in a single name and the account were to have joint names, we would have called it a transfer. Similarly, from single name holding to joint name demat account is a case of a transfer which cannot be permitted. Very often people come back saying, hey, it's only my spouse and why should you not permit? The fact is, it is a transfer and we cannot permit it because that is not as per the law. So this is something which often comes up. Name mismatch is a very, very common thing. Also because the practice, originally when we had the IPO, huge number of IPOs in the early 80s, people applied for shares in different combinations just to ensure that chances of allotment in public issue went up. Today, they find it difficult to link that name. The name in which they would have applied may not actually be their name, but they hold the share certificate and they've not encashed the dividend because there was no bank account by that name. Because if you're able to prove something, the company has some link. If there's no link, the company is not a judge to be able to link the person. Of course, we've seen multiple issues with respect to physical shares. When they give a death certificate, we find that the certificate of death is not there on the record the way it is shown. So I think given all these complex issues, there's always a cautious approach of the companies because it's something which will lead to a liability on the company. And how do you say you've acted in good faith unless you've done a thorough checking? There is nothing that you can just take for granted. And today there are these questions which come up. So therefore, checking and enhanced due diligence as mandated by SEBI also is put into play. And that is the reason they see it. Very often what happens is shareholders and we've seen this, they apply for, they send the papers with respect to one particular folio and write letters with respect to another folio where they've not sent any papers at all. To the person, it is his shares. To the company, it's two different folios, and you're not going to be linking one folio with the other. More importantly, if the second folio you're holding with another family member of yours. So these are commonly there are several problems that we find with respect to physical folios. Suffice it to say that if these shares get dematerialized, I'm sure Tunal, I, and several other company secretaries would be happier because the pressure would be taken up not by the company secretaries, but it would then move. And it will actually not be pressure because it will be a very smooth process with the original shareholder getting his own shares in his demat account. Demat has proven itself very well. Once it is dematerialized, it's a safe way to keep an electronic record, similar to a bank account. As much as we have in the bank, the shares are safe in Demat, and that's exactly what needs to be mentioned. Lastly, I would just like to spend 1 minute on the Niveshak Shibir, which was also mentioned by Mr. Jeevan in his initial remarks. This is something which the IEPF authorities, along with SEBI, would like to do to be able to locate the missing shareholders. In particular, after expiry of 7 years, we send the shares to IEPF. The effort is mainly aimed at looking at cases where the shareholders are made aware and they actually can come to the Shivir, meet the officials. Few companies would also be there, and they then see as to whether they have their shares and all. A similar exercise was done by IEPF in Bombay about 1.5 years ago. Unfortunately, instead of the original shareholder, a lot of the brokers came there, and that was not really what was expected. So, IEPF wants the actual genuine shareholders to be there. So, they're going to be possibly looking at the Aadhaar card and registration and taking the process forward so that they basically assist the investors in making their claims. With this, let me hand over to Tunal. And if there are a few questions at the end of the session, I'll be happy to take them on. Thank you very much.
Thank you, Savitri. Savitri, there are so many, there are 10 questions and 15 questions are with me, which sent by email. And I want you and Tonal both should be there. So I will, Tonal, you share your experience and solution because Reliance has no doubt it has a market capitalization, but the complicated case is with the ITC. They have a shares, bonus, split, multiple things. Okay, over to you, Tonal.
Yeah, I don't need the presentation. You can remove it because already a presentation in detail has been done.
Okay.
And for me right now, more than the challenge of physical share is the challenge of speaking after Savitri ma'am, who so very well covers everything. You are left wondering what you speak now. Okay. So yeah, the future for the securities transfer definitely is 100% digital shareholding. That's the inevitable shift, and a complete phase out of the physical shares is just a matter of time. We have already traveled a long distance towards that goal. I would say we have traveled probably 90% of the journey. Now, what we are left with are what Piyusha has already explained, that for certain XYZ reasons, people have still, hold on to their physical shares. But the major chunk of the shares are already in demat form. And like Savitri ma'am said, it's absolutely a smooth journey there. And the role of the companies are far lessened and absolutely hassle-free. Just to give a little touchdown on where we stand today, in case of listed companies, basically, there is still no mandatory deadline for dematting the shares. People can still hold on to the shares, although transfer of shares is no longer allowed. So you are basically just holding on to your shares. That's all you can do. And the moment there is any transmission of share or any issue of duplicate share certificate, etc., you have to compulsorily move your shares to demat form, because after effecting those procedures, companies are going to give you a letter of confirmation, and you have to effect demat of shares within 120 days. If you don't do it, your shares will be transferred to your suspense account. So it's just a matter of time, when all these shares get transferred into demat form. In case of unlisted companies and private companies, which are not small companies, issue of securities are compulsorily in dematerialized form now. And these companies are asked to facilitate dematerialization of the existing securities. Transfer of shares 100% has to be in demat form. And whenever any promoters, directors, KMPs, and other persons have to apply for new shares in these companies through private placements or buybacks or bonus rights issues, they have to ensure that their existing holdings are converted to demat form. So you can understand the push that the regulatory authorities are giving for converting all the shareholding into demat form. All these moves which we have discussed, that you have to update your KYC information, link your PAN with Aadhaar, this letter of confirmation instead of issuing new certificates, are just pushing shareholders so that they can convert their shares into demat form today or tomorrow. Also, now from last year, what has started is if your account is not KYC compliant, you are not even entitled to dividend payments. Dividend payments have to be done only through electronic mode and only for the KYC compliant folios. I would like to cover some challenges that shareholders holding shares in physical form nowadays face. Change of name, which have already been covered. Like, I would also like to add on a little bit here. See, like Savitri ma'am said, in the past, many shareholders have used any which name they feel like to register the shares. Today, that is backfiring on them because SEBI's regulations now say that when you effect change of name, you not only ask for ID proof of the new name, including gazette notification or marriage certificate, etc. But more importantly, you also need to produce ID proof of the old name. Now, people who have registered shares in the name, sometime a household name or a pet name, where will they bring that old ID proof? They don't have any such ID. To make matters more complex, the regulations, the SEBI circulars now say that unless specifically prescribed, companies cannot ask for indemnity and affidavit wherever they feel like. So in the past, what used to happen is, in case of name mismatch, etc., companies used to take some affidavits from the shareholder where they used to confirm so and so and so and so is the one and the same person. And basis that, we used to go ahead and effect change of name. But now our hands are also tied. We cannot take affidavit, indemnity in all such matters. So there are certain bottlenecks, in these areas where people get stuck up. What to do, that clarity is not there. Likewise, many often what happens is there is some dispute between the joint holders, like arising out of marital problems or divorce, etc., where people who were holding shares together as joint holders in the past, now they don't want that. They want to hold the shares in physical form. At times they are not in good terms also, and getting signatures, etc., is also not a problem. Is a problem. So here, as per the new law, we cannot, change the ownership of the shares because transfer of shares has been prohibited. Now, people in those kind of situations where they are not in talking terms or in dispute, they cannot open a demat account in their joint names too. So as a result, what happens is the shares are lying without any solution. Only solution that they have got is to go to a court and file a litigation. In case of legacy shares, like in our company is a very old company, likewise Reliance also, and similarly other old companies, there are a lot of disputes, in respect of old shares due to bad delivery problems, etc. The shares have continued to lie with some broker or with some investor without getting, transferred in their name. Today, when they come back after, getting the shareholder signature, etc., there also the matters get stuck up because transfer of shares have been discontinued. Like if SEBI comes up with a window, like Jeevan sir was saying in the beginning, a one-time window where shares will be allowed to be transferred in physical form, then only we can have a solution to these problems. Otherwise, the only solution is to go and knock in the doors of the court and get a court order, which of course takes a long time. We also face issues with some non-residents. At times non-resident relatives are made nominees or become legal heirs, and these people who have left India a long time back in the past, they find it very challenging now to come and open demat account to get these shares, because there is no way they can get the physical shares. Post transmission, it is compulsory that the shares have to be given in demat form. So these are few hardships, which shareholders are facing these days, and we cannot offer too much of solution also. Only exception is perhaps to go and approach a court of law. Now, the different scenarios which Piyusha's presentation was covering, like if a person is a shareholder himself, the situation is quite a simple situation. He just have to ensure that his KYC is updated, and then he can demat the shares. Unless, of course, if the certificates are not available, then he has to apply for issue of duplicate certificates to the company, submit the prescribed documents, and then a letter of confirmation will be issued to them, basis which they have to demat the shares. Situation becomes complex when the shares are standing in the name of a person who's not registered as the shareholder. Now, this situation, like Piyusha was saying, there can be a multiple factors. Sometimes transfer deed is available, sometimes certificate is available, transfer deed is not, sometimes both transfer deed certificates are not available. There can be multiple scenarios. However, we have to look at, for solution of this, we have to look at what we used to do in the past and what are the options that we presently have. Like, for example, if the transfer deed is available but the certificate is missing, in the past, we would have issued a duplicate share certificate and in the name of the registered shareholder, and then basis the transfer deed, we would have transferred the share in the name of the investor and giving the new certificate with a endorsement to the investor. But in today's scenario, the transfer of share itself is stopped. So how do you solve these problems? The only solution is the shareholder himself will have to apply for duplicate certificate to the company. Once duplicate certificate is processed, a letter of confirmation will be issued to that shareholder, who basis that will have to demat the shares in his account. And once the shares are dematted, only then in dematerialized form, the shares can be transferred from that shareholder to that investor. So you see that complete scenario has now changed. Earlier it used to be simple. This transfer process used to happen in the physical form itself and certificate used to go to the investor. Now, unless they demat the shares, they cannot get the shares registered in their name. And this obviously would mean that they would require complete cooperation from the registered holder till the end, which sometimes is very challenging, because once the registered shareholder has executed the transfer deed, we have found very often they do not cooperate after that. At times, they are even not reachable. In such a situation, the shares get stuck in the hand of the investor. If that happens, the only solution is he has to go to a court of law to get the shares registered in his name. Likewise, the other scenarios also almost similar, situation is arising. Like, for example, if the transfer deed is also missing and the certificate is also missing, there also it is the same thing, that the shareholder will have to apply for duplicate certificate, and once the shares come to him in his demat account, then only he has to transfer the share in the name of the investor. And again, it has to be an arrangement between the shareholder and the investor. The company has very little role to play here. Because even if they give their proof of purchase and broker slip or payment proof and all, what do we do with that? Our hands are tied. We cannot transfer, we cannot change the ownership in physical form anymore. Whatever has to happen in the demat form only. So these various scenarios, these have completely changed with the prohibition of transfer of shares in the physical form. Of course, the work of the company has reduced here. We have to just guide them, what to do. But for the investors, for the shareholders, these are hardships which they have to deal with. Regarding IEPF, Piyusha has covered well. Yeah, there are a lot of challenges there. Firstly, if you people who are holding shares in physical form, if they keep their KYC updated, the scenario will not arise that your shares will go to IEPF. If you have not updated your KYC and you have not been getting your dividend, then only your shares or dividend will go to IEPF. But once it goes to IEPF, although it is claimable, however, the process is not simple. And though regulations prescribe certain deadlines that within such and such days they have to return your shares in dividend. However, the practical part is that it takes months and sometimes years for shareholders to recover the shares or the dividend from the authority. Companies are involved. Payusha was covering that there are delays in getting the letter of entitlement at times. I obviously, from my company's point of view, I can say that we maintain certain standards in terms of time within which we issue these letters of entitlements to the shareholders, because that's the very first point basis which only they can, start the claim. However, companies also will require time, because at times these shares where shareholders apply to the company for this letter of entitlement, we find there is a lot of history in the shares. These are lying unclaimed for several years, signatures don't tally, multiple claims can remain in the records of the company. So a lot of digging out of old records are involved, particularly if the history is old for the shares. And moreover, the companies are ultimately responsible for whatever thing go wrong here. Like basis our issue of letter of entitlement, eventually the authority will release the shares or the dividend to the claimant, of course after doing their own verification. But if later on any forgery or fraud is discovered, who is responsible? The companies. Neither the shareholder nor the authority nor the agencies which help in the shareholders to claim the shares. It is the companies who are going to be responsible. We have indemnified the authority. So little bit extra time we will definitely take to ascertain the genuinity of the claim before we release the letter of entitlement, because our interest is also at stake here. Having said that, yes, there is a lot of delay in the procedure, to the extent that even after approval of the claims, people don't get the shares or dividend. And you are right when you say that there is an absence of communication, absence of a human interface to ask the status of the case, where is it lying, why is it lying, when it can be recovered. So there is a lot of gap which is there in this area. So best thing, of course, is don't get into a situation where your shares or dividend go to IEPF in the first place. Now, even after all of these hardships, if you still wish to hold physical shares for some reason, certain things you have to do. One is you must ensure that you are KYC compliant at any point of time. Like whenever you move, you please make sure that you communicate your address, current address to the company, keep your email ID updated, have your shares nominated. If you change your bank account details, please advise it immediately to the companies, because if you don't encash dividend, again, you're opening the way for your shares dividend to go to IPF. You have to preserve the share certificates in safe custody to prevent any loss, theft, accidents, forgery, fraud on that. Because if you lose your certificates, whether you like it or not, you have to eventually move to electronic form, because company is not going to issue new certificates to you anymore. Besides significant financial complications, you have to keep track of the corporate actions, because if you're holding shares of the company and you don't know like whether that company is getting merged or amalgamated or demerged, then you lose track of your investment and you lose out. So you have to keep track of all the corporate actions which that company whose shares you're holding is doing. Nowadays, of course, there is a lot of investor education which SEBI has promoted. Like you will find investor charter, FAQs on these various service request matters available on the website of SEBI, as well as even companies are required to put this up on their respective websites. So these are all for creating investor awareness and make the investors more educated, so that they do not lose out on their investments and they don't suffer. Be also aware of the investor complaint mechanism. If you are if you have any issues with any company or any registrar or anything, you must know the investor complaint mechanism. What is the escalation matrix? How to file a complaint in scores, how to file a complaint in smart ODR portal. everything you will find on the websites of the respective companies and the websites of the RTAs also. That's a mandate which is given by SEBI. So as an investor, you should be aware of all these things. So I would end it here because the rest of the topic is already covered, and I'll wait the questions that come. Pawanji.
Thank you very much. Thank you, Tunal. Your experience is reflecting in your discussion that what types of cases, and very well covered. Savitri has covered one portion. You have covered from the company side. Now over to Raghav, because he is interacting and Piyusha is interacting with the clients and these questions. So Raghav, over to you. We have a short time, so we have to take a question answer session also. Okay.
Sure, sir. Thank you. So, Piyusha has covered all the points related to the physical shares, and Mr. Tunal and Savitri ma'am has explained the intention of the company as well, that they want everybody to have their shares in their demat account. And I think company would be the most happiest person in this scenario if everybody gets their shares in their demat account. So, in this scenario, Mr. Tunal have mentioned that in some cases of name mismatch, the company is required to have particularly old name proofs. And now, in most of the cases, the shareholder does not have their old name proofs. And now they are, and Mr. Kunal mentioned that even their hands are tied, and without the old name proof, then they cannot move with the request of the shareholder. So in such case scenario, even I don't have idea that how one shareholder who does not possess the old name proof will move or will have his or her shares back. So this is one question where I think I don't have answer, and if anybody, any of the panelists can provide me an answer, that would be great and very much helpful for the shareholders. So this is a particular one point. Apart from that, Mr. Tunal mentioned another point, that whenever a service request is for the entitlement letter has been made for the company takes their time to look into the history of the shares on that particular folio, that how many requests or a transfer attempt or other such kind of things have been done by any person in relation to those shares. But that delay, sometimes that delay causes really great loss to the shareholder. In one of the cases, what I have seen, that one particular shareholder mentioned to a specific company that his father has already deceased in 90s, and he has provided death certificate, and he has also provided a letter of administration. That was an NRI case, so he has also provided letter of administration from US authorities that so and so person died 20 years back, 20 years or 30 years back. And in that case scenario, company took time to reply to that person. And meanwhile, some other guy, he filed a claim with the company that I am the person, and company transferred such shares to that person. They provided him the letter of confirmation, and that guy got all the shares. But the claimant of the original shareholder, he did not even got any answer. So that the delay on the part of company cost him huge loss. That was the another issue. And in most of the cases, the name issue with the name, as Mr. Tunal mentioned, that people used to use many abbreviation, nicknames, family names, combinations for more and more allotments. So now these have created more troubles for the investors. And on the part of investors, the biggest problem what they have is the proof of their old addresses and old names. So obviously, asking somebody after 30 or 40 years to provide a proof of their old address or proof of their old name is really very difficult. They cannot provide you such things. Because in most of the cases, they have been migrated to different addresses. And in many cases, people have shifted to altogether a different country. So providing a old name proof or a old address proof is really difficult for them as well. So in that case scenario, I think either company and the authorities, SEBI and IEPF also, they should think something. They should come up with a particular solution to help such kind of people, because they are really suffering. And if the company is not the right person to help them, I don't know who can provide a solution to such kind of people who's having these problems. So I think that is all on my part also, sir. And I think we can move to the question answer sessions.
Okay, thank you very much, Raghav, because we have received various questions, so it's better we can just start this. So I'm starting from first question. That is, when a company split the face value of shares, it is still required to issue share certificate, or can the shares simply be credited on a escrow account? The law appears to be unclear in regard. I think Savitri, in this case, there's no share certificate you are issuing. If there is a demat share, it is automatically credited.
That's correct. So, if you refer to Regulation 39(2) of LODR, it very clearly covers split also. So, when you do a split of shares, that is when the face value of the shares is reduced, let's say from 10 it becomes 2 rupees per share or 1 rupee per share, the split shares will only be issued in dematerialized form. And in case a person is holding shares in physical form, typically what is done is at least 15 days before the record date, the shareholder concerned is required to give copy of the CML and other details to the company, so that directly credit of shares is given to the demat account. If he does not do that, the shares will then be kept in the suspense escrow account, from which it will be released after the person is able to give the CML details.
Okay. Okay. But why he's saying the law is unclear?
No, the law is very clear. Tunal, any doubt on this law?
Okay. In a closely held public company.
No doubt.
Yeah.
Okay. A closely held public limited company, a shareholder transferred physical share on 1st April 2024, a submitted document to the company. However, the transfer is no longer traceable. How can the transfer share the? I think this is a closely held company, public limited, that is not a listed company, so I'm not covering this case. Okay. If a shareholder has passed away, no dividend have been received for several years, and the shares are in physical form, are the shares transferred to central government? If yes, what is the process for legal heirs to reclaim? I think it is not transferring to the IPF if it is no dividend they have given.
Yeah, but let's assume in the past, not 7 years, but several years ago, dividend was declared, which is still shown as unclaimed. Then the shares will also go to IEPF, because there was a subsequent amendment to the initial IEPF rules, which required these kind of cases also to get transferred. This was sometime in 2019, if I recollect, the amendment was made, pursuant to which the shares got transferred to IEPF. You're on mute. Pawan, you're on mute.
Yeah. How can one obtain dematerialization share in case where the company has been closed or it's under winding up, and the original shareholders, deceased parent, are no longer live?
Why do you want to demat will be my question. Tunal, if the company has
Yeah,
wound up,
exactly.
क्या करोगे?
Well, the shareholders lost, sir. That's it.
Yeah.
Nothing.
I
But
think there is
yeah, but what is happening nowadays, Savitri? A company is going for insolvency or winding up. Suddenly there is something happening and they are coming out, and somebody is taking over and doing things. So that time you do. Otherwise, there is no sense to do this because company is closed or winding up. But closed company can be revived. So what is the solution then?
Wait for a revival. Keep watching. Keep
Yeah.
keep the share safe.
hold on to the shares till then.
Correct.
Yeah. A shareholder has submitted form ISR2 certified by Citizen Cooperative Bank. The RTA is rejecting it, claiming the bank is not included in the RBI list of scheduled cooperative banks. However, the shareholder asserts that the bank is listed. Please specify the validity of this certificate.
No, if the bank is not in the scheduled list, then the RTA is right in rejecting it. Is to get it from a bank which is recognized.
Okay.
This is attesting the signature of the shareholder.
Okay, but suppose I have only one account in this bank. So it means I have to open in another account?
Yes. Yes, because see, that is why specifically a list has been drawn up, because there has been several instances where bank attestations have been found to not being genuine, leading to loss and fraud, forgery, etc. That is why this whole provision has come.
Does the requirement of dematerialization create practical difficulty in enforcing transfer restriction agreed upon between shareholders under private agreement? What is
Kunal, go ahead.
Yeah, see, now the transfer of shares has to happen in demat form only. So if there is any arrangement, a private arrangement made between two parties, then they'll have to open a demat account first, get the shares dematted, and then only transfer. So it's very clear now. Physical transfers is no longer, possible.
Okay. Ragam and Pusha, what is the geographical distribution of 378 crore lakh crores market? Understanding the regional dispersion will help in tailor out outreach strategy and to better serve investors across different parts of the country. So, which is the state has the highest number of physical shares?
Well, it's really hard to define, but Maharashtra, Delhi, Gujarat,
Maharashtra.
West Bengal.
Must be
Majorly
Maharashtra.
metropolitan cities
Actually,
and
West Bengal has a higher. West Bengal has so many shareholders.
Yes, you're right, sir.
Kunal?
Yeah.
Okay.
I don't think it'll feature in the top list.
Okay.
Must be Maharashtra or Gujarat. Maybe Maharashtra.
Okay. Why are the stock exchange not facilitating the creation of ISNI number, even though companies like ours are fully compliant and ready? We seek clarity on the process and the reason for delays or bottleneck in ISNI number nuisance.
No, I mean, this matter is to be taken up with the depositories concerned, because when you apply for the ISIN, you apply to one of the depositories. And the
Okay.
companies will have to take it up with the depositories. I mean, what is the reason for delay? Because normally it would take, the entire checking and all that takes about a week or so. But
That's right.
if it's taking much longer beyond 2 to 3 weeks, they must take it up with the depository concerned.
Okay. Can physical share be transferred to the suspense account after sending 3 reminder letter to shareholders in accordance with the applicable regulation?
Yeah, that is the requirement. Not 3, I think 2. There are 2 reminders required to be sent, one after 45 days, one after 90 days. And after 120 days, it is moved to the suspense account.
Okay. Can an existing investor in Series X participate in Series Y, even though Series X is not yet dematerialized? We have a case where such an investor wishes to subscribe to Series Y. Is this permitted and what compliances condition must be fulfilled?
So there is no bar on subscribing to the next one, which is issued in demat form, because now all the shares have to be issued only in demat form. So if he is going to be subscribing to the next one, you can't stop him from subscribing. But with respect to the old one, you can cajole him to go into a demat mode. Like, say, for example, rights issue. If a person applies for the rights shares, giving his demat account, you cannot stop him because he's anyways a shareholder.
Okay. Okay. Can the exist as per regulation 39(4) of schedule 6 of SEBI LODR regulation? Is it permissible for a company to send 3 reminder letters to shareholder whose share certificate have been returned undelivered and subsequently dematerialize those shares, especially in case where the company has undertaking a share split? Anyone?
Go ahead, Tunal.
Yeah, see, I didn't understand the share split part, but first part is yes, if the share certificates have come back undelivered, then after sending the 3 reminder letters, it is to be moved to unclaimed suspense account.
Okay.
But what is the relation of the share split here? Didn't understand.
Okay. So, and who has sent this question, please specify, you give reply. Okay. Now, Piyusha, legal here certificate is to be obtained from court or notarized affidavit will suffice.
the legal aid certificate is obtained from the SDM office, Revenue Office department. And once it is obtained, you have to give the notarized copy of the same or you can give a certified true copy in the duplicate form to be submitted to the company, and it should be self-attested.
Okay, okay.
And it is also very important to note in this legal heir certificate, sometimes what happened, the person has deceased, but one of the deceased legal heir of the deceased shareholder, the claimant comes up with that legal heir certificate. It should be important to note that the person who's the shareholder who's deceased, the legal heir certificate should be in his name only. Like, it should be from his departure only.
Okay. I'm a joint shareholder with my brother in Glaxo Pharmaceutical. My brother passed away in US in January 18. I submitted a notarized copy of his death certificate to KFintech, the RTA. However, they returned the document saying they need either the original death certificate or one authenticated by the Indian Embassy. I don't have an original. Interestingly, KFin accepted the same document for ICICI Bank share. What I can do?
Well, that was the mistake. He must have to submit a certified true copy. That's the only thing. That's the only solution.
Okay. My father passed away in 1973. He holds 40 shares in NOSIL. After his death, the company issued 20 bonus shares in 76. We submitted succession certificate in 79, but the company asked for another one for the bonus share, which the court rejected. Now they say there is no folio number and they cannot trace the shares. What should we do? So it's a very interesting point.
Multiple cases like this come.
I think one will have to go into some more details on this particular case. When the company is saying there is no share, are they basically saying that it has got transferred in someone else's name, or what actually is the case? We need to understand,
Okay.
because folio number not existing is not possible.
Okay.
Sir, I would like to ask one question here, similar to this question itself. Like if the person has obtained the succession certificate, likewise in the said case, he has obtained the succession certificate for 40 shares. And the bonus shares, suppose 40 more shares have been issued, but the succession certificate does not say anything about those bonus shares, those 40 bonus shares. So will that company transfer the letter for all those 80 shares, or will it just consider those 40 shares?
Sorry, come again, Piyusha. Are
For
you saying
example,
that 80 shares have got transferred
yeah,
to IEPF? Just come again.
80 shares have transferred to IPF. Now the investor has obtained the succession certificate only for 40 shares. Okay, so in such scenarios, whether the company will process for only 40 shares or it will process for the whole or 80 shares lot.
The company will give you an entitlement certificate for full 80, because the original shares, which are the base shares, he has established his ownership. The bonus shares are just an accretion to the original shares. Nothing further is required with respect to that. So it's quite possible that they may have applied for the succession certificate before the bonus was declared. Okay. So the company will issue it for the
Yeah,
entire thing.
I think when they have applied for succession certificate, that is very important to see here, because it may happen that they have applied for succession and then bonus issues have accrued. So naturally, companies will not again insist for bonus accruals. But if the succession certificate has been applied at a time when bonus had already been issued and they have applied for half the number of shares, then it could be a different scenario.
Okay.
Okay. So then that base rule will not apply, you say.
Yes.
Okay.
Okay. So now next is we have obtained ISNI in the company label, but due to certain succession and probate issue, shares have not been dematerialized at the shareholders level. This is for an unlisted public company limited. Is that a problem?
So long as the shareholder is not transferring the shares, he is entitled to hold the shares in physical form, except in case of promoters. Because with respect to unlisted public companies, also the promoters' shares have to be dematerialized. So if it is not a promoter and just a shareholder, all that the company is required to do is to get an ISIN, facilitate dematerialization. Nothing more is required as per the rules very clearly stated, stating this. Let's assume you are an unlisted public company with, let us say, 1,000 shareholders. You're not going to go and ask each of the shareholder, except for maybe sending a letter. You're not going to ask all of them to convert their shares into dematerialized form. You've taken an ISIN, promoter shares are in demat form. That's fine.
Okay. One person is asking what to do with the delisted and non-traded shares. Is there any mechanism to claim from the company? So delisted, you can't do this. You just wait the regulator compulsion. The regulator, if compelling them, then you can get. And the non-tradable shares, you wait, because trading can start at any time if the company is surviving. Physical share certificate are in the name of Mr. A, which were listed on the stock exchange long back. These shares were not dematted, and Mr. A holds the share certificate. The company has not declared any dividend. How and when Mr. A can claim money on these shares?
Mr. A has not transferred the shares, right?
Yeah.
Fine. And if the shares are in his possession, let him first apply to the company to check whether they have been sent to IEPF or they are with the company. If they are still with the company, then he can apply for dematerialization.
Yes.
If they're not with the company, then he should apply for IEPF claim.
Okay. Even though the instruction by SEBI requires the registrar to inform the shareholder about any shortcoming in the KYC document, in all my cases, the registrar returned the documents.
Registrar has what? Sorry, didn't
Return
get
the
the last
document.
one. Returned the document.
Take it up with the registrar.
Yeah,
Okay.
unless his address is not updated, registrar might have sent to the old address.
Okay. He's
That is also
asking,
one of the KYC point.
He's asking further the name of the person and the contact detail of the person at the registrar rejecting the returning the document is not given in the letter requiring the document to the shareholder. Registrar should be asked to follow the instruction about objection as well as given contact detail of the person handling the matter. He is suggesting this. Okay. We are holding 10,000 shares with a face value of 10 each under category 3, means shares held in the name of other person, ownership not established. We have both transfer deed and share certificate available. How can we regularize this? How you can help us in this? For helping, you can come to Piyusha. For asking question, Savitri and Tunal can give. So he has physical share. What he can do now?
So
See,
actually, these are the kind of cases which Mr. Jeevan was also mentioning will possibly go to the panel. So what you have to see is, along with all this, in order to establish proof, he should also see whether he has any, see the transfer deed, whether the originating broker is a registered broker. Very often you find on the reverse of the transfer deed, the stamp that is put does not have any number. So, and if it is a well-known broker, there should be no issues with respect to the establishing of the shares having gone to the stock exchange in a proper manner. Or otherwise, see whether you have any other proof, because these are the things which will eventually come up. Over to you, Tunal.
yeah, I would have said the same thing only, ma'am. Right now, if you ask, there is no solution because transfer cannot be done in physical form. We have to wait. If SEBI opens that window, then we'll have to approach that.
Okay. Okay. Despite submission of all document, approval from IEPF often takes a year. Are there any plan to streamline the digitize the process and ensure faster turnaround times, Piyusha?
Sir, this is exactly like my question also, because even if many of our cases we have received the approval and it's been 7 months, we have seen the shares are still
Okay.
not credited.
Okay. Now it's a rapid round, so we have to be very short. Currently, there is a limited visibility on the real-time status of claim. Will the IPF authority introduce more transparent tracking system to regulate communication update or claimants?
Well, IPF authority is already in the process of making some mechanism wherein the shareholders can, track, real-time track can be there for their status.
As per recent law, legal hair certificate may be used for case where market value or more than 5 lakh, but RTA still insists for succession certificate. Can legal hair be used such cases? Tunal, what is the position? If the
No, RTAs will have to follow by the SEBI regulations. They can't create their own regulations.
but which are
If
the
SEBI
RTA
prescribe-
which are the RTA?
The KFIN technologies we have personally seen. The market value is more than 5 lakh. They still ask for succession certificate. However, as per September 2024 circular, IPF was already specified that legal heir certificate is a suffice document, even if the market value crosses 5 lakh.
Okay.
So
In case the changes in surname due to marriage, even when the shareholders has sufficient proof of old name and has passport in the new name, where the name of the spouse is clearly mentioned, is there still a requirement of 2 gazette notification or marriage certificate? Raghav, Piyusha?
Sir,
Gazette is not required, but marriage certificate is something what RTA will require, and it's also mandated in
So
law.
marriage certificate from the registrar office or Mandir?
they're from a registrar office.
Okay.
It's required. If marriage certificate is not available, the last resort is always a gazette notification.
Okay. Tunal, you are also following the same?
Yes.
Okay. Where the person has already given a gazette notification for name change, why is there a need to old name proof by RTA?
This is prescribed by SEBI.
Okay.
We have to follow by the regulations.
Okay. 20 years back, a listed company allotted equity share to its employee. Being employee of the listed company, someone got 100 shares in physical form on that time. Subsequently left the organization and even forget about the holding, being no document available with him as on date. In 24, said company decided to issue right issue and sent communication to all the existing shareholders. Being the holder of 100 shares in physical form, the person also received the letter from the company and now he recalled about his holding. Subsequently, he opened a demat account, applied for right issue with necessary place payment and allotted and credited 67 in dematerialization share in the document itself. Now, how he will convert 100 share of physical form of dematerialization, number one. Whom to approach, exactly what are the form to be filled for this purpose. Are there any online process? So, I think Tunal, you must have faced this
No,
type of
his
problem.
original shares, they are lost. He doesn't have, right?
Forget, you forget.
So he has to apply to the company or to the registrar for issue of duplicate certificate, and
Yeah.
they will prescribe or send to him the formats of the documents which SEBI has prescribed for issue of duplicate certificate. Once he comply with that, a letter of confirmation will be issued to him, basis which you have to demat the shares. So
Okay.
that way the originals will also come to his demat account.
Okay. Okay. Last question. If husband and wife, two holders in physical share, now both divorce, how to demat shares?
So they have to somehow mediate in between. First of all, they have to mediate to an extent. They have to open a joint demat account. Get those shares demat.
He will say, मैं तुझे खा जाऊंगा, वो कहेगा मैं तुझे खा जाऊंगा. Then how can they open the demat account?
I think court order in this will also be helpful,
Okay. Okay.
provided market value is high and the cost will be less accordingly.
Okay. So I think we have already crossed 3 minutes and we have to wind up this program. So before, thank you very much, Savitri, Tonal, Raga, Piyusha. You have given extensively. And thank you, Savitri, for taking initiative on this program and suggesting me to do for the investors. And it is a great help to the people. Anybody who has not received the satisfactory answer or they have a non-clarity still, you write to us, we'll reply to you. So
Thank you very much. Thank you. And
as a-
I'll have to drop off. So I'll
No,
just
just
drop off immediately.
last comment you give and go.
Yeah. Thank you very much, Pawan. I think it really was a good program. And in fact, I must confess, I didn't expect so many questions on this. And probably, we've addressed to the best of our ability. Some of those where the registrars have to answer, I'm sure Raghav and Piyusha would be able to take them up. Thank you very much. Let me
And we will
now.
organize another program with calling IEPF some RTAs also. Okay.
Certainly. Thank
Okay.
you very much.
Kunal,
Thank you.
thank you, Savitri. Kunal.
Thank you so much for the opportunity. It was a great learning experience for me as well. Hope I am able to give some answers which help people. And it was a very relevant topic. And thank you so much for organizing this.
Thank you, Kunal. Raghav.
Well, it was a great session. Everybody, I think, have provided all the answer, whatever running in the mind of the investor, physical shareholders particularly. But at the end, one advice: don't hold on to your physical share certificates. Just get them dematerialized. That's the only thing you can.
Okay, okay. Piyusha,
Well, thank you so much, sir, for inviting us here. Well, I hope all the physical shareholders have all the queries. We have listed down each and every query here. Still, you have any questions, you people can reach out to us. You can mail your queries. We are there to help you out. We'll assist you accordingly.
Okay.
Thank you.
thank you, Piyusha. Thank you, Raghav. Thank you, Tonal. Thank you, Savitri.
Thank you so much,
Thank
sir.
you, Jeevan sir, for giving introduction. So, friends, it's a time to close this session. And if you have any other question or any other issues, you can contact us. You can write to us. If you have any problem, you can contact Wealth Finder. Raghav and Piyusha will help you to do this. And thank everyone. Now, as you are aware that our knowledge session is continue. So 6th June, we are having our program on the occasion of World Environmental Day celebrating on 5th June, decoding EPR for PIVOs from compliance to implementation. Till then, thank you very much.